Welcome, everyone. My name's Howard Gould. I'm co-chair for the real estate section for the Beverly Hills Bar Association, and we're happy that you're all joining us for the program today on ethics for real estate lawyers. I want to let you know about some upcoming programs. We're going to do a program next month on syndications. We haven't done anything on real estate syndications in quite a while. We have a program the next month, which is our annual case update on the prior year real estate cases from our courts. We are then going to have a program which we try to do annually, which is an update on the California Association of Real Estate Forms. And we're having a speaker back who's done a great job for us a couple of times in the past to talk about any new forms or changes in old forms. Other programs in the near future will be a program on short-term rentals and our annual property tax update. In terms of today's program, there's a couple of messages for you in the chat, but otherwise for Q&A, please put your questions in the Q&A. We're not going to monitor the chat, but we will be monitoring the Q&A, and the chat, in fact, may be turned off. And finally, Beverly Hills Bar will get you your MCLE certificate shortly after the program. They generally are very prompt about that. It's my great pleasure today to welcome our speaker, Joel Osman. Joel is senior counsel and general counsel to Parker Chaffee LLP, where he concentrates his practice on litigation and trials with a significant emphasis on ethics and professional responsibility matters. He has significant and long-term affiliations before Parker Chaffee, which include Travelers Insurance and Anderson, McFarland, and Connors. Mr. Osman, for over 7 years, back in 2006 to 2013, managed operations of 5 Travelers offices in Southern California, from Diamond Bar down to San Diego, with a multi-million-dollar budget and 54 employees engaged in the defense of Travelers insureds in general liability, auto, fire, and subrogation matters. And his additional responsibilities there included in development and delivery of presentations and programs, including training programs, and that was both internal and external programs. He served in several national roles, including a founding member and chair of the Staff Council Standing Committee on Ethics, which was part of the Staff Council to Travelers Indemnity Company. As senior partner at Anderson, McFarland, and Connors, Mr. Osman represented clients in cases involving professional liability, general liability, product liability, construction defect, and commercial litigation, trying numerous jury trials to verdict. He's focused much of his interest on the defense of lawyers and legal ethics. His current professional activities include membership in the LA County Bar Association's Professional Responsibility and Ethics Committee, which he chaired in 2008 to 2009, and he served a 3-year term through 2018 as a member of the State Bar's Committee on Professional Responsibility and Conduct. So you have the right person giving your presentation to you today. He has law degree from UCLA and his undergrad from UC San Diego. And Joel, welcome, and educate us about ethics for real estate lawyers.
Well, I hope to educate you about ethics for real estate lawyers. Let me start by sharing the screen so you can all see the PowerPoint presentation. Okay. The first point I want to make to everybody is that there is no such thing as just ethics for real estate lawyers. There's just ethics. And what we're going to try to do today is try to make this discussion about general ethical principles relevant to the particular field of your practice or your interest in real estate. But I want to make it clear to you, I'm not myself a real estate practitioner, but I do know a fair amount about the California Rules of Professional Conduct. California Rules of Professional Conduct now are closer to mirroring the ABA model rules than they've ever been. In November of 2018, we adopted a new set of rules, which, among other things, now numbers our rules in a manner similar to the ABA rules. Virtually every state in the union uses some version, and there's substantial variation, of the ABA model rules, and we are now among that set. Before we get going, it's important to understand why these rules are important. Number one, because if you violate them, you can be subject to discipline by the bar. And number two, a violation of ethical rules could possibly result in a disqualification of you from some matter, usually a litigated matter, obviously. Number three, you might be guilty of malpractice if you violate the rules. And number four, perhaps most important to some of us, if you screw up and make a major rules violation, it could have a negative impact on your reputation, and none of us really wants that to be the case. Again, repeating myself here a little bit, or I was ahead of myself. These are the same ethical rules that apply to everybody, no matter what your practice. It doesn't matter whether you're a criminal lawyer, a real estate lawyer, a malpractice lawyer. It's all the same rules, but we can tailor our discussion to focus on how it may apply to your particular field of interest. It's also worth noting that there are a variety of different sources of laws and rules which regulate California lawyers, and you should be at least passingly familiar with all of them. First and foremost, we have the rules of professional conduct. Now, these are rules which are promulgated by the state bar and ultimately approved by the Supreme Court. And you can find these rules on the state bar website. If you click under ethics and click under rules, you'll find both the current rules, those which have been enforced since November 1 of 2018, and the prior set of rules. There's also the State Bar Act, which you can find in the Business and Professions Code at section 6000 et sec. What you'll find if you read through the State Bar Act is that some of it is basically duplicative of what's in the rules. The explanation for that is fairly simple. The rules of professional conduct are promulgated by the bar and approved by the Supreme Court, and the State Bar Act is a creation of the legislature, which frequently feels that it has a role in governing the conduct of lawyers and protecting the public from misconduct of lawyers. And sometimes, not all the time, but sometimes those two roles, that of the Bar Association and the legislature, appear to be in conflict, or at least they both want to get their say. There's rules which are redundant in both sets. Howard, you look like you're about to say something.
Yeah.
Okay. You also need to be aware that the California rules of court weigh on our ethical responsibilities. And finally, you need to be aware that there's reported case law which addresses this. Those cases include not only cases reported from the state bar courts, but also general cases which frequently, particularly in the realm of malpractice, will address issues having to do with legal ethics. So we're going to start today by talking about our duties to a prospective client. In a nutshell, and I won't read these slides verbatim because there could be hardly anything more boring than doing that for you. In a nutshell, you owe any prospective client the same duty of confidentiality that you would owe to a client, somebody who actually becomes your client. It doesn't matter that you've not yet formed an attorney-client relationship. If you talk to a prospective client about any potential engagement, whatever they tell you is confidential, and you owe the same duties to protect that confidence that you would owe if they ultimately do become your client. In that regard, if you haven't taken a look at Rule of Professional Conduct 1.6 or Business and Professions Code 6068E, I highly advise you to do that. 6068E is perhaps even stronger than the RPC in that it says that lawyers shall protect at every peril to themselves client confidences. This is possibly the most important tenet in all of California ethical law. California, and arguably California, has got stronger ethical rules with respect to attorney-client privilege and client confidences than any of the other states. This is serious, no fooling around business. What you learn in the course of a confidential client representation, even one that hasn't yet started, needs to be protected at all costs and cannot be used for any purpose outside that representation. Even if the information is discoverable, if you can Google your client or your prospective client and get the same information, if you learn it in the course of talking to a prospective client or an actual client, it's confidential and you have to preserve that confidence. There's also comments in Rule 1.18 about not representing clients with interests materially adverse to those of a prospective client. Again, we'll get to this momentarily, but this emphasizes the importance of conflict checking early before you get into any substantive discussions with your prospective clients. Best practices vary slightly, but in our firm, we try very, very hard to not have any substantive discussion with a prospective client until after we've completed our initial conflict check. The way we do that is typically we have a non-lawyer employee respond to inquiries about possible representations, get the conflict information that's necessary, run our initial conflict check, and then only after that do we actually engage in any substantive discussion about what's going on. The design of this process is to avoid situations in which we inadvertently stumble into somebody, getting information from somebody that is actually in conflict with one of our existing clients and possibly imperils our ability to continue the existing representation. We'll talk a little bit more about conflicts and conflict checking as we go on through the rest of this presentation.
One comment I think that's worth talking about now for people to focus on when we go through these discussions is that real estate matters frequently involve more than one party, and that's sort of the frame of mind you need to be listening to this program with. A property may have more than one owner, even if it's just husband and wife. Arguably, you have two owners. A partnership, some sort of joint venture, an LLP. You're going to have to be thinking about the communication, disclosure, and privacy issues really from the beginning of the discussions with whoever you're talking about.
That's a very good point, Howard, and one that we'll get into a little bit later in a couple of additional slides. There are additional things that you have to do to be careful whenever you're representing more than one party or could be possibly construed to represent more than one party. A final point here with respect to Rule 1.18, if you do come across information that might disqualify you from the representation of a current client while talking to a prospective client, you can get around that if you get the informed written consent of both parties. Emphasis on written. Whenever the state bar asks you to get somebody's informed consent, it is almost always in writing. And if you don't have it in writing, you haven't adequately complied with the rule. More details about which comes and follows on with what I said about do your conflict check first. You want to be able to demonstrate you took all reasonable measures to avoid exposure to information. And if you discover that you've got a lawyer within your firm who is privy to information or has a conflict which creates a problem with respect to your prospective employment, we now, for the first time, well, since November of 2018, we have the first time we actually have rules that acknowledge the possibility of ethical screens. Before 2018, we had at least one reported case decision that talked about it. There were other jurisdictions where there was a possibility of imposing an ethical screen to get around a conflict problem. There was certainly a lot of conversation about it, but we didn't actually have a rule authorizing it. Now we have not only this comment in Rule 1.18, but we also have further details in Rule 1.10 talking about imputed context or conflicts, which we clearly know that you can now create an ethical screen, and we know more than we used to know about how to do so in a way that would be adequate to keep us from having a conflict because of something that one of our lawyers did in a past life or in a past association. This is a particularly important concept now that we live in an era where we've got more attorney mobility than we used to have 40 years ago in the business. One of the things that I think is particularly relevant for your particular practice area is if you are interviewing a prospective client and that client, you want to be sensitive to the possibility that client is in a business where he's actually competing with one of your existing clients. And if that is the case, you want to look very carefully at it to determine whether that competitive relationship in some way creates a conflict that makes it ill-advised for you to take on the new prospective client. Now, it's not, I can't give you a hard, fast set of rules as to what that might be. And maybe the decision might be motivated more by business considerations than by actual ethical considerations, but it's something that I think each of you should consider when talking to prospective clients. There are a finite number of people, for instance, who do real estate development. If you do real estate, you've got a client who does real estate development in one geographic location, and your prospective client is a competitor, there may be issues there, some that you're not even aware of at the time, which might make it ill-advised for you to take on the second client.
And Joel, in line with your prior comment and a question we had, your advice is that the best practice is to have if you have a competent non-lawyer staff person, they conduct the initial conflict information retrieval for you rather than the lawyer doing that.
It doesn't have to be, because I suspect that knowledge even to your non-lawyer staff is imputable to you. But we find that that's the best way. Sometimes it doesn't work out that way. Sometimes I'll end up collecting the conflict information. I'll make the initial contact and get that information myself, or the staff person doesn't get enough information and I have to recontact the prospective client to get more, to do an effective conflict check. But we make every effort to try to avoid substantive conversation until after the conflict check is done. Now, does this work perfectly every time? No. There's the guy says, well, let me just tell you a little bit about what it's about. And sometimes you are not going to have complete success in avoiding that. But do the best you can to show that you've made a reasonable effort to avoid exposure to problematic information. Which brings us back to the point I was making a few moments ago. Conflict check, first, last, and always. We always start with our conflict check. Now, there's a variety of different ways that you can conduct a conflict check. In our firm, we happen to use what I think of as a sort of a two-tiered approach. We checked based upon information in our litigation. We're a litigating firm, so I refer to it as a litigation management system, but it's basically a document management system. And then we also, because we're a relatively small shop, poll every one of our lawyers for every single engagement, because not all of us have been here indefinitely, and people may have had contacts with potential clients in their prior employment, which would be problematic. You don't have to do it that way, but you do have to have some sort of definitive, well-established system in which you conduct your conflict checks. And let's take a moment. We're talking generally about the process of onboarding clients. This is frankly both has ethical implications and frankly it's just sort of risk management and business management implications as well. We start with the premise that every one of our legal engagements is eventually going to come to an end, one way or the other. Whether you're a litigator, whether it's a transactional engagement, whether you have a long-term relationship with a real estate client that for one reason or another ends, all relationships basically end. If we pay proper attention to the details at the beginning of that relationship, it will have a positive effect on making sure that the relationship, when it does end, ends in the most positive way possible. Conversely, if we fail to pay proper attention to the details at the beginning, it might create problems when that relationship eventually does end. One of the things we want to keep in mind when we are starting the relationship is also one of the requirements of the rules of professional conduct. We want to know your limits. Rule 1.1 tells us that we should not intentionally, recklessly, or with gross negligence or repeatedly fail to perform legal services with competence. In other words, you're not supposed to try to undertake to do stuff that you don't know how to do. Competence is defined as any legal service, in any legal service applying the learning and skill and mental, emotional, physical ability necessary to perform the service. Now, this does not mean that you can only take on engagements for things that you've already done. It does mean, on the other hand, that when you do take on an engagement, either you need to know what you're going to be doing, or you need to make the commitment to become competent and knowledgeable about what you're going to be doing. You don't have to know everything, otherwise how would any of us ever get started? When I started, I certainly didn't know how to find my way to the courthouse, let alone do anything particularly useful for my clients. But I did have the resources of the firm in which I worked. I did have a reasonably agile mind, and I did have a willingness and ability to become competent about things that I hadn't done before. And that's what you need to do in order to satisfy this requirement.
Joel, would you say that another uh, sort of device to do this and give proper advice and protect yourself is you bring in a second person? This, you have to look at the finances of the matter, of course, and how that affects the client, but you bring in someone else to advise on specifics. For example, I had a case, it was in probate court, and was a copyright matter, and I brought in counsel from both of those specialties to assist me.
That's exactly correct, Howard. If it's not your competence, you need to avail yourself of somebody else's competence to cover areas that you're not competent in. Also, remember that the concept of competence here implies not only your knowledge, but your emotional and physical ability. If you or a member of your firm become unwell or unable to perform your work for some period of time, then you should make alternative arrangements to see that that client's work is adequately completed and protected. For instance, if, God forbid, a member of your firm is either physically or emotionally unwell for a period of time, as members of a firm or a partnership, you want to be aware of that, and you want to take steps to protect the client's interests so that that infirmity doesn't negatively impact on the work that you're doing for any of your clients.
I think one good example of this is I got involved in a matter where two partners were trying to split up, and there was an old property tax issue they hadn't dealt with. They had a plan in place when I was brought in to represent one of the partners to sue the county assessor, which didn't sound to me like the right idea. And I contacted one of the people I use frequently as a speaker for this section on property tax matters, who immediately told me, no, that's the wrong idea. He had a great idea that he had used before, and we managed within about 45 days of filing the case to get a judgment, which was then going to be binding on the assessor's office anyway, even though they weren't a party to the case. And it was an example of how, even though I do a lot of real estate work, by calling on somebody who was a specialist in property taxes, and they handled one side of the case and I handled the other, we got it resolved very effectively and very quickly. And it turned out that both myself and the other real estate lawyer who had been involved for the other partner didn't know of this specific procedure that was available. And we managed to give competent advice by bringing in the specialist.
That's exactly correct. And again, you don't have to know everything before you start. You just have to know what you what you don't know, and find some way to fill the gaps. Either learn it yourself or engage the services of somebody who knows better than you so that the client's goals can be best achieved. Another thing that we advise people, and this is really more risk management and business management than it is ethics, I think it's a good idea for you to know as much as you can about the potential client in order to determine whether this is a potential engagement which is going to end up reasonably successful for both you and the client. If you have a guy who walks into your office, whether you're a litigator or a transactional lawyer and doing real estate work, who has unreasonable goals, it may not be possible for you to satisfy that client. Now, in my area of practice, I've occasionally run across people who say, look, I want to wreak havoc on a biblical scale against my opponent. And I'm immediately thinking to myself, this isn't going to end well, because he's more passionate or more angry or more unreasonable than I'm capable of being. Is this somebody I really want to represent? Am I going to be able to do work that will satisfy their expectations and not create a problem in the relationship that I'm developing with, or posing to develop with this client? Now, it's easy when you've got enough people knocking on your door and enough things to do and enough hours of work to fill the time that you've got available. It's easy to be a little bit more fussy about that. Not all of us are always in that happy position, and sometimes it's kind of hard to turn down the possible work when the phone isn't ringing as much as you want. But to the extent that you could possibly do so, be on the lookout for potential clients' expectations and whether you can actually reasonably achieve them within the limits of what you can do in the law.
I think those are great points. And there's sort of an idea that in a way goes along with this, is that it's not just sometimes the potential client, but the potential transaction. Sometimes, there's neighbors who have a dispute and they want to readjust something here or there. And what is easy to miss is not just the potential client, but what other parties to the transaction are going to be involved. And a frequent example of that is the lender. Sometimes there's a lender who has an interest in what arrangements you're making regarding your real property, especially if you're changing boundary lines or you're doing other things like that. And it's a good idea to sit back, think about what's going to be involved and what third parties are going to have an interest, whether it's an insurer or a lender, because that may affect the ultimate course of action that you that you look into, or the outcome.
That's a very good point, and you raise an excellent example. Neighbor versus neighbor disputes, whether it has to do with a property line or some nuisance or other things, are particularly fraught with danger. They tend to be the real estate equivalent of family law, and it's sometimes particularly difficult to craft any sort of resolution short of utter destruction of one side or the other that's going to keep, that's going to satisfy at least one of the parties. You want to be sure that you know what you're getting into and frankly know whether you want to be able to pursue that goal. So how do we address these things? First of all, we want to be able to control the scope of whatever we're engaging to do. We want to make sure that if we do engage with a client, we want there to be a clear mutual understanding as to what the scope of that engagement is. In California, we can have what's called a limited scope engagement. You can say, I'm willing to do X, Y, and Z for you, but I'm not going to do other things. And that's perfectly acceptable under our rules. It turns out in this regard that your retainer agreement is really your best friend, because it allows you to clearly set forth. Well, first of all, it should be noted that if you're going to be doing any work on an hourly engagement that's got an anticipated value of more than $1,000, you need a written retainer agreement, or else you're only entitled to a quantum merit recovery for your fees. And secondarily, it allows you to set the stage and control your client's expectations and clearly set forth what. I apologize, folks. I forgot to mute my phone.
Joel, is that for individuals and corporations both, or is it just
both?
Both.
There's for any client really, and we, in our practice, because a lot of our practice involves dealing with lawyers or dealing with clients who have a proven propensity for suing their former lawyers, we pay a lot of attention to what our scope of our engagement is, because we want to manage those expectations. We want to say what we are willing to do and what we aren't willing to do. In our particular practice, for instance, we typically exclude at the outset, we're not going to do any appeals for you. We're not going to give you any tax advice. We're not going to give you any bankruptcy advice. You could adjust those things based upon the nature of your practice, but you want to view your retainer agreement not just as a requirement, but as a tool to manage those expectations and frankly, to protect yourself. One of the things you have to do in order to have an effective retainer agreement is to figure out at the outset who your client is going to be. Howard mentioned corporate entities. There are challenges when you represent corporate entities, particularly if it's a parent, subsidiary, or affiliated corporation. You want to figure out which one you actually represent and which one you don't represent. There are issues that could arise, for instance, if you're working for a subsidiary corporation, but the parent corporation thinks that it has some rights to control the engagement or to affect the engagement or to benefit from the engagement. You want to clearly understand what entity you're going to be representing, to whom you're going to report and from whom you're going to take your instructions. If you are concerned about organizations as a client, there's a rule of professional conduct which addresses that. That's rule 1.13. In a nutshell, it basically tells us that when you represent a corporate entity, the corporate entity is your client, not the individuals to whom you answer.
One other thing to consider on the business, not the ethics side, is are you representing the entity that actually has assets and cash flow? Because if not, and there's a big bill at the end, you may find you have the wrong party signing your agreement.
Good point. Ethics are important, but getting paid also counts for a lot in our business. Again, when you take on the representation of an entity, you represent the entity, not the individual directors, officers, or managers, even though those people may treat it as if they're the client, and even though those people may try to hit you up for information or questions about their relationship with the entity that you represent. These are situations where there's a fraught with the possibility of some sort of conflict, particularly if there's discord and unhappiness within the entity that you are being engaged to represent. Same thing happens when you're representing a real estate partnership. You represent the partnership as an entity, not the individual partners. And we try to be very careful to set forth in detail, remind the client, this is the entity that we represent. We represent, we're talking to you in your capacity as an officer or director or partner in this entity, but you individually are not our client. Your individual interests are not what we're here to protect. And if you get into a squabble with your co-investors, whatever the organization may be, we are not going to be the ones who get to referee that problem for you.
There's another thing to remember in real estate matters. Somebody comes to you and maybe there's a construction project or development issue or something else regarding the ownership, and you understand that you're talking to the owner of the property. But too often what happens is when you look at the legal title, it's not what you thought and it's not what you were told or what you assumed. So unfortunately, in some of these matters, it's a good idea early on to call your title company rep and make certain they give you the current vesting of the property so you know who the true owner is, because it may not be what you think or even what you're told.
True. In your particular field with real estate, if you're dealing with real estate trusts or family entities which own property, and this is Howard gets credit for this when he pointed out while we were preparing for this, you want to look for possible conflicts between the members in possession of the property and others who are part of the family entity or real estate trust. All of these things could create issues which might somehow impair your ability to complete the engagement. Also, we spoke earlier about joint representation. If you have more than one person or entity you represent, you need to recognize there's a potential conflict every time you represent more than one person or entity, and you need to take that into account, even if it's a husband and wife, to the extent of doing a conflict disclosure and waiver whenever you do represent more than one person or entity. Even if you don't think that they're currently in conflict, even if you think that their goals are totally aligned, a careful practitioner is going to say, look, I think that there's no impairment to my representing the two of you, 2, 3, or 4 of you. We don't perceive any current conflicts, but we want to make these disclosures to you about what's going to happen if and when you start disagreeing, who's going to control the litigation, whether we're going to be able to continue representing one or all of you, and most importantly, from whom are we going to take our instructions and report to. So these are things that we typically do if there's going to be a joint representation of more than one entity or person. We'll not only do a retainer agreement, but we will also incorporate by reference a separate conflict disclosure and waiver, again done in writing, which we will ask the clients to sign and return to us in writing, evidencing that they're aware of this, acknowledging it, and consenting to the joint representation. Finally, you get weird situations where you have a third party agreeing to pay for your services on behalf of another. Now, this may be in the real estate context, you're doing a purchase and sale agreement, and one party says, I will pay you to write this purchase and sale agreement, but it's for the benefit of everybody, all the parties to this agreement. Or maybe you've got a situation where you've got an insurer involved or a lender involved, and the lender's offering to pay for the services that you're providing. Insurers are a weird situation because by law they have you have what they call a tripartite relationship, where the lawyer represents both the insurance company and the insured and has duties to both. But even if it's not an insurance situation, if you're taking money from one entity to do work on behalf of another entity, you need to disclose that fact in your retainer agreement and get the client to consent to that and acknowledge that, in essence, yes, this person is paying you to do this work for me, but they're not controlling it. I'm the client, and you're not going to be influenced by the fact that they're paying you.
I have a couple of practice tips on this page. You want to put into your fee agreement that there is not going to be attorney-client privilege vis-a-vis the husband and wife or the partners or the shareholders, so that it's in writing at the outset and everybody understands that what one of them tells you is not privileged information versus the others. And you may even have an obligation to disclose to the others what you're told by one of the other principals in the transaction. So I put in the fee agreement that there is no privilege in that situation. Secondly, you want to have in your fee agreement a specific instruction, or excuse me, a specific language that it tells you who you are allowed to take instructions from. Otherwise, if it's a husband and wife, you may need to get both of them to send you something, even though one of them is really dominating that engagement. Same thing with the partners, joint ventures, things like that. You want an instruction in the fee agreement that says who you can communicate to, and maybe you'll communicate to everybody, but also which of those people can give you instructions. And as Joel said, if somebody other than the client is paying the bill, it has to be approved in writing.
All very good points. Typically, we include all of those either in, if we're doing it in one document, it's in the retainer agreement. If we're doing it in two documents, it's a retainer agreement and a conflict disclosure / waiver, which is incorporated by reference into the retainer agreement. The last point on the subject of who's your client, you want to be aware of the potential of an unintended client and the possibility of conflicts arising out of that. Among the reasons we pay such close attention to defining who our client is and to using our retainer agreements to make clear who our client is we don't want to inadvertently have people saying, well, you were acting on my behalf even if I didn't sign this agreement, and I'm not happy with what you did, or because you were acting on my behalf, I'm going to be able to make a claim against you because I'm not happy about how things came out. And this can be everything from the person you speak to at a cocktail party and answer his questions, to a third-party beneficiary, to a real estate trust, or something like that. So you want to, as carefully as possible, define who you represent, who you don't represent, so that you don't have somebody who you didn't ever think of as being your client coming back to you at some point in the future and saying, hey, I'm not too happy about this. What are you going to do about it? Again, to repeat, and I know I'm being a little bit pedantic about this, conflicts are not a one and done deal. You don't get to do a conflict check at the beginning of an engagement and then ignore the whole subject. If something changes during the life of the engagement, new parties to the transaction, new parties to a litigation, the nature of the transaction changes, any new circumstance which causes the interests of formally aligned or neutral parties to diverge, you need to check that and rerun your conflict check, because such developments could somehow give rise to a conflict that would impair your ability to continue to represent these parties.
What if it's an investment tool and there's a new investor, so you have a new principal involved, or there's a new joint venture that takes over something that you're working on, or
then you're going to want to rerun your conflict checks.
Or your client asks you to inform somebody else of what's going on, and you probably want to confirm in an email, you've authorized me to inform so-and-so about this subject matter.
That would be an issue of confirming in writing that you've been authorized to share client confidences or attorney-client privilege information. But whenever somebody new shows up in whatever it is, a litigation or a transaction, you want to stop for a second, take a look and see if this somehow gives rise to a conflict that you weren't previously aware of. So how are we going to avoid all this nonsense? First of all, again, we're going to make full use of our engagement letter to define who the client is and the scope of the engagement. We're going to update our conflict checks when new parties are added to the matter. We're going to close matters promptly and update our firm's systems. You're not always precluded from taking positions adverse to former clients, but you want to make sure, A, that the former clients, and B, that the new matter is not factually related, either factually or temporally related to the prior engagement. In order to do that effectively, you have to keep your systems update. You can't have, 10,000 unclosed matters out there where somebody might argue that this is still an ongoing relationship. So typically when we're done with a matter, whether it's a lawsuit or some other transactional matter, we write a definitive closing letter to the client. Dear so-and-so, this has happened. This brings our litigation to a close. It's been our pleasure to represent you. This engagement is now over. This does a couple things. Number one, it potentially opens up the possibility of taking engagements for people who are at some point in the future adverse to your now about to be former client. And number two, it starts the clock running on any claims this client may make against you by way of establishing a clear end to the relationship and the commencement of the running of the statute of limitations. So now we know who our client is, and we've have to figure out what kind of conflicts might arise. They typically arise in 4 different situations. You've got concurrent conflicts, clients who are directly adverse in the same matter. That's pretty easy. You've got former clients adverse to a current client in a different but related matter. You've got clients who are adverse in unrelated matters. You have clients in substantially related matters with or without disclosure of confidences. So we need to turn our attention to Rule of Professional Conduct 1.7, which is the main rule, talks about conflicts of interest with current clients. And first and foremost, it tells us that a lawyer shall not, without informed written consent, those magic words again, from each of his clients, represent a client if the representation is directly adverse to another client in the same or separate matter. Pretty simple, pretty basic. You'd be amazed how often people screw this one up. But you can't represent 2 sides in the same matter. Second part, a lawyer cannot, without informed written consent of each effective client, represent a client if there's a significant risk that the lawyer's representation of the client will materially limit the lawyer's responsibilities or relationship with another client, a former client, or a third person. So again, kind of redundant, but a slight variation on the theme. Not only can you not represent adverse parties in the same transaction or matter, but you can't represent adverse parties if there's a significant risk that doing so is going to impair your responsibilities to another client. When a significant risk requiring a conflict waiver is not present, a lawyer shall not represent a client without written disclosure of the relationship to the client and the compliance with paragraph D. If the lawyer has or knows of another lawyer in the law firm, that another lawyer in the law firm has a legal, business, financial, or professional or personal relationship with or responsibility to a party or a witness in the same matter. This gets into the notion of imputation. Not only do you have to worry about your own conflicts, but you have to worry about those of the other members of your firm. Most of us don't practice by ourselves. Well, I take that back. A substantial number of us don't practice by ourselves. And so when we are considering conflicts, we have to consider not only conflicts arising from what we know and who we've represented, but also conflicts arising from what the other people in our firm may have. Also, the same applies if the lawyer knows or reasonably should know that another party's lawyer is a spouse, parent, child, sibling lawyer. So you remember there's a Spencer Tracy movie, many, many years ago, in which it posited a husband and wife lawyer team. That's not so, without written conflict waivers, you're not going to be able to do that. Made for a cute movie, but it's not a reality in real life. Now, you can have a representation in situations A, B, and C if the lawyer reasonably believes that the lawyer is able to provide competent and diligent representation for each affected client. The representation is not prohibited by law, and the representation does not assert a claim by one client against another client in the same litigation or proceeding before a tribunal. The same would be true, by the way, for transactions as well. And finally, the rule reminds us again that you cannot use information relating to the representation of a client to the disadvantage of a client unless the client gives you informed consent. What you learn in one transaction cannot be used to the disadvantage of that client in another transaction, even if it's entirely unrelated. Go back to Business and Professions Code 6068E. What you learn in confidence stays in confidence unless the client tells you otherwise. And again, you remind you of Howard's comment a few minutes ago. If a client says, I want you to share this with X, put it in writing, get them to confirm, yes, you are authorized to share my client confidence with X. It's fair to the client, and it's a good CYA technique. Another potential area that's rife for conflicts is if you're accepting compensation from one other than your client. And this goes back to what we talked about a few slides back. If you're going to be accepting money from a third party to represent your client, you have to do so in a way that makes sure that there's no interference with your independent professional judgment on behalf of the client that you are going to represent. And you have to obtain the client's informed written consent of this. By the way, in the insurance context, which probably doesn't relate too much to your business, but was near and dear to my heart at one point in my life, there's a specific case law in California which says, yeah, an insurance company can have you represented by their own in-house counsel, so long as the insurance company doesn't interfere with the independent professional judgment of that counsel. That was a big deal back in the day when I was actually managing a bunch of insurance in-house lawyers to represent insureds. And in fact, the case law which covers that was generated prior to my arrival for that company by lawyers in the outfit I eventually controlled. Another potential problem here is aggregate settlements. This happens more in the context of litigation than it does in real estate transactions, but say there's a transaction which results in a lump sum settlement. You've got more than one client and you have a transaction which results in a lump sum payment to your clients together. You need to make sure that the clients have clearly defined and who's going to get what out of whatever is recovered from the transaction, and that any dispute that arises out of that is doesn't create a conflict which prevents your effective representation of the entity or the group of individuals with whom you're engaged to represent. You also have conflict-related duties to former clients. A lawyer who's formerly represented a client shall not thereafter represent another person in the same or substantially related matter in which that person's interests are materially adverse to the interests of the former client unless you get informed consent. Again, we go through various iterations of here, but again, we're once again reminded you can't disclose client confidences in a new engagement that you received in a former engagement. And it's also, this affects not only your former engagements, but former engagements that are imputable to you through other members of your firm. Finally, we get to the rule that talks about imputation, which is Rule 1.10. We're getting down to our last 10 minutes, so we're going to skim through this just a little bit, but bottom line is, if I have a conflict, my conflict is imputed to everybody in my firm. If somebody else in my firm has a conflict, it's imputed to me. That's why when we do our conflict checks, we're careful to poll not only what the firm's own corporate memory, but the memories of the individual people who've come to work at the firm at any given time to look for potential past conflicts. Now, the good news is if you do have a conflict, 1.10 and also 1.18, which we discussed earlier, now recognizes for the first time the possibility of creating an ethical screen. In the interest of time, we're not going to go into a lot of detail as to how that ethical screen has to be created, simply to note that it does exist. It is a real live thing in California, and law firms, particularly larger law firms, make great use of this now. It allows them to expand the scope of the people that they can represent. In fact, really big law firms will typically have language built into their agreements, sort of blanket pre-consent to conflicts and to screening as necessary to avoid conflicts. The language varies from firm to firm, but the basic intent is, hi, we're mega law firm. We have 7,000 lawyers around the entire world. We represent lots of different entities, some of whom, even unknowing to the attorneys who you're working for you on this particular engagement, may be in conflict with you in some way that we don't yet know about. And you're sort of pre-consenting to, if such conflict arises, are screening those people off so that we can continue to represent you in this engagement. You look like you're about to comment, Howard.
Yeah, on the other hand, there are times when people decide they just can't do this. I had a significant corporate fight. Whitman Breed Abbott out in New York was one of the firms on the other side, and they were acquired during the case. And there was a determination made that there was a conflict between that office in LA and the acquirer, and that office in LA all joined Holland and Knight out of Florida because of that conflict of interest. And I also know a lawyer who was at one of the big local firms recently, an old friend of mine, and he had a very large matter coming in, and he ended up leaving his law firm and setting up a local office for an out-of-state firm so he could take on this significant new matter because it was a conflict that they just couldn't avoid. So that there are occasions where that there some drastic things happen because of these conflicts of interest.
There are occasions to do that. You need to be careful if you're saying, well, I'm going to take my bat and ball and go set up my own shop so I can do this. You still have to be careful to protect client confidences to which you were privy before you left the shop from which the conflict arose. And you know, going off and setting up your own shop may allow you to do that and avoid the conflict, but there may be other problems with respect to knowledge and information imputable to you that was received by your prior firm that may interfere with your ability to do that. All of this is, again, particularly relevant in an age where attorney mobility is certainly much more common than it was 40 plus years ago when I started in this business. And again, a reminder, those client confidences survive movement of the matter or the attorney from one firm to another. So it's not always the answer to say, well, I'm taking my practice in this case to Holland and Knight, and there I've solved my problem. Holland and Knight, by the way, has some excellent people in the general counsel office. They have a lot of people who are really, really good on ethics, so they might not let you anyways. But you want to be aware of that. That's kind of a drastic solution to a potential conflict problem, and it may or may not solve your situation. So in our last 5 minutes, I've got a conflict. What do I do? Well, your choices are kind of limited, but fairly clear cut. Either you get the people who are subject to the conflict you inform them of the conflict and get their informed written consent to waive that conflict, or alternatively, you're going to have to get out of the engagement, or you're at least going to have to stop representing at least one party to the engagement. So among the other things we do when we're talking about a joint representation of multiple parties is we'll build in the event a conflict arises, you agree in advance that we can continue to represent X and we'll stop representing Y, or something to that effect. If you don't build that in, you're probably going to be in a situation where you're not going to be able to continue to represent either party when a conflict arises. You don't get to pick and choose unless you actually have the client's agreement and written consent before the conflict arises. There's a concept called the hot potato rule, where you don't get to dump the problematic client and keep the good one. And it's not a pretty choice. It's not something that any of us want to have to do, which is why we try to go to so much care in the creation of the attorney-client relationship and the conflict checking and the disclosures to avoid it. If you don't take care to do that, you're going to ultimately find yourself in a situation where a conflict arises and you are just SOL. You're not going to represent anybody because you can't do so in an ethical manner. Howard, by my clock, we have about 4 minutes left. I have not been able to see the Q&A, so I don't know if we have
Now,
questions.
we don't have other Q&A, so I'll tell one sort of uh, roughly related war story, a very strange thing. But, we all think of LA as being a very big place. But as you get older, like I am, you find all kinds of interconnections between people. I mentioned before two partners trying to separate, and one of them came to hire me, and I brought in the real property lawyer. Well, it turned out the lawyer on the other side had formerly been a subtenant of mine. It's just one of those coincidences. But more closer to the ethics side, I had a neighbor dispute, and I was representing a lawyer against the neighbor. The neighbor had been there for 25 years, and their name was Brown. And I didn't really make any connection, but I had hired a new secretary. We were a small office, and she'd only been with me a couple months, but she comes into my office and says to me, the Browns that your lawyer client has an issue with. She says, well, my last name, as you know, is Brown, and they happen to be relatives of mine, and I go to their house once a year. And it didn't seem like a big deal, but I felt I had to disclose this to my client. And when I did, he said, well, it's either me or your new hire. And I was put in this awkward position of basically having a conflict where my client said, I could either represent him or I could keep the employee, but not both. And it's just one of those peculiar things that, well, LA seems like a big place, especially in West LA. There's a lot more interconnections than one realizes.
There are, and I'm sure that was a difficult choice, but ultimately I want to applaud you for having done the right thing and saying, hey, I don't think this rises to the level of legal conflict, but I want to tell you this. That harks back to something I said earlier on when you talk about knowing your client. We have a lot more resources now than we used to try to know some things about potential clients. I regularly check the internet. You can't do it. You can't do it on a pretext. You can't pretend to friend somebody on Facebook or Twitter or whatever else. But if there's publicly available information out there, there's nothing wrong with looking for it. And I do. Typically, I represent a lot of lawyers. We represent lawyers who've been sued. We represent lawyers who have state bar issues. We represent lawyers just on an ethical consulting basis. I always Google my potential clients up to and including their state bar profiles. Because if I'm going to take on an engagement or I'm going to try to help somebody with who's got a state bar investigation, I want to know what their prior disciplinary history is. There's nothing wrong with that, and there's often a considerable benefit to you as the attorney to know more rather than less.
Joel, one inquiry is whether you've had a situation where the prospective client is interviewing your firm and numerous others in order to preclude an opposing party from hiring you. I mean, there's stories about this happening, and that some people will try to do that.
There are apocryphal stories about that. It happens also in the context of expert work, which is another thing that I and another member of my firm do a lot of. And again, not to continue my preaching, conflict check before you do it so that you can avoid that possibility. And sometimes you just get stuck. Sometimes it is possible, particularly in the context of an expert. We may not show up a conflict. We may not be engaged, but because we receive some confidential information, when the next guy calls us up, I'm not going to be able to take that engagement. I'm not sure how often this happens in real life. It may be more apocryphal than real, but it's a concern, and it's not one for which I have a good answer.
Yeah, there have been a few cases over the years where there are many like homeowners involved. Maybe it's a hillside, bluff case where the bluff's collapsing and a lot of people are going to be making suits against various people, and somebody comes to you, but are they really the member of that community you want to represent, or are they going to have a small claim compared to other people with larger claims? And if you're really in that line of work where a number of people are maybe coming to you from the same community, and can you represent multiple people or not under the circumstances? So, sometimes somebody will represent the whole community, but sometimes there are conflicts. So
there can be, and you want to be aware of the problem about an aggregate settlement when you're representing multiple claimants. Back in my misspent youth, I spent some time defending construction defect cases, and we were often asked, well, can you represent more than one trade as a cross defendant? I'm not entirely sure now, with the perfect sight of hindsight, whether I gave the right answer or not. I'm not entirely sure whether we were careful enough about disclosing the potential conflicts of representing multiple clients. Those were different times, and I wasn't the same ethical lawyer then that I am now, apparently. But these are all issues that you need to consider and you need to be aware of. And hopefully, with the benefit of the last hour's discussion, you'll have some additional reminders and tools that will help you to do that.
Joel, thank you so much. It's wonderful to have you give this presentation. Joel works at a wonderful firm. I've known David Parker almost since I moved to LA, 40 years ago. And, Joel is a great resource. And we thank you for taking your time to prepare this and put on the presentation today. And thank you to everyone who's attended.
It's been my pleasure. Thank you, everybody.